Welcome, everyone. Today, I would like to talk about a recent court decision from the United States, which deals with the training of AI and the relationship to copyright law, as well as the so famous fair use exception. For this, I'm joined by my colleague, Lauren Cury. She's an expert in intellectual property litigation and a partner at Hogan Lovells in Washington, D.C. Welcome, Lauren.
Thank you, Morten. And thank you very much for having me.
So let's start with the facts of the case. The District Court of Delaware had to decide whether the AI startup, Ross, infringed the copyright of the large legal publisher, Thomson Reuters. Thomson Reuters operates the well-known legal research platform Westlaw. Ross Intelligence is a new competitor in this field and has built an AI tool that can help legal professionals with their research by identifying, retrieving, and sorting relevant case law. However, AI tools must be trained before they can be used. So in simple terms, this means that they have to learn the legal context from existing data. And that was controversial in the case. Did Ross train the AI tool using legal content from the Westlaw database and thus infringed Thomson Reuters copyrights? Thomson Reuters accused Ross of using thousands of so-called head notes from the Westlaw database to train the AI tool. And the head note is a brief summary of the key points of the decision, which is provided in Westlaw's database. It summarizes the content, but it's not part of the decision. Before the dispute, Ross had tried to obtain a license to use Westlaw's head notes for training its legal AI. However, after the license was denied, Ross used then a different approach and trained the AI using bulk memos, a form of legal memos which Ross obtained from a different provider. Bulk memos are lawyers' compilations of legal questions and answers. The parties are now in dispute over whether Westlaw's head notes were nevertheless used indirectly in the training process. Or in other words, if Ross built its competing product using bulk memos, which in turn were built from Westlaw's head notes, as the court said. So first of all, the court addressed in its decision whether these head notes are protected by copyright at all. Is that right?
That's right, Morten. Under U.S. copyright law, a work must meet a minimum threshold of creativity in order to satisfy the originality requirement for copyrightability. That threshold, though, is very low. You just need a spark of creativity to meet it. Here, while the court held that the Westlaw head notes are only minimally creative, it did find them creative enough for copyright protection. In fact, the court found that each head note is an individual copyrightable work that introduces creativity by distilling, synthesizing, or explaining part of a legal opinion. To illustrate this, the court used a colorful analogy, comparing legal opinions to blocks of raw marble and analogizing head notes to sculptures that have been chiseled out of them.
Interesting. We have a similar feature in German legal databases called lead sentences, which summarize the main legal aspects of a decision. These may also be protected under copyright law. So let's get to the main elements of the decision. Did the court see Ross' behavior as a copyright infringement?
It did. To find copyright infringement, the court needed to find actual copying, namely that Ross did in fact use the head notes in creating its AI tool, as well as substantial similarity, namely that the bulk memo questions materially appropriated the Westlaw head notes. It ultimately found both. On actual copying, the court based its decision on a combination of Ross's access to the Westlaw head notes and a comparison of the bulk memo questions with both those Westlaw head notes and the judicial opinions they summarize. It reasoned that if a bulk memo question looked more like the head note than the actual opinion, this was strong evidence of actual copying. On substantial similarity, the court took a similar approach, granting summary judgment where the language of the bulk memo questions very closely tracked the head notes, but not the language of the case opinions they summarized.
So the court found that many of the disputed head notes infringed Thomson Reuters copyright. Ross tried to defend primarily with the fair use exception, right? So this is a term from American copyright law that I understand is often used in connection with AI training. Am I right? And could you briefly explain what fair use actually means?
Sure. Fair use is a defense to copyright infringement in the United States, and you're correct that it's the primary defense being advanced in the various pending AI copyright cases. Fair use is itself a highly fact-dependent analysis. It considers 4 factors. First, the purpose and character of the use. Second, the nature of the copyrighted work at issue. Third, the amount and substantiality of the portion of that copyrighted work that's used. And then fourth, the effect on the potential market for the copyrighted work. Now, in this analysis, no factor is dispositive, and there are no bright line rules for weighing them. So each case is analyzed on its own merits.
Very interesting. So the fair use principle is always heavily dependent on the individual case? And
It is.
Yeah, and how did the court decide in this case?
Well, here the court determined that Ross's use of the Westlaw headnotes in training its AI tool did not qualify as fair use. The court walked through the 4 factors that we just discussed and considered them one by one. First, the court considered the purpose and character of Ross's use, determining that purpose was commercial in nature and that it wasn't transformative, namely because it didn't have a further or different purpose than that of Thomson Reuters. The court also determined that the intermediate copying exception, which has been applied in some U.S. software cases, did not apply here, including because the intermediate copying wasn't necessary to innovation and because the works at issue weren't computer code. As a result, the court found that the first factor favored Thomson Reuters. Next, the court looked at the nature of the copyrighted work, namely the headnotes that were at issue. As we've discussed, the court had already determined that those headnotes were only minimally creative, such that this factor favored Ross. Third, the court analyzed the amount and substantiality of the headnotes reflected in Ross's work. The court explained that this factor looks not at how much of the work is used in making the copy, but rather how much of it is made accessible to the public. Here, because Ross only used the headnotes in training and did not make them accessible to the public at all, the court found that this factor also favored Ross. Finally, the court considered the effect of Ross's copying on the potential market for Thomson Reuters headnotes. Because the purpose of Ross's tool was, according to the court, to compete with Westlaw, and because the court found that Ross hadn't shown that its use would not affect a potential market for Ross's headnotes as AI training data, the court concluded that this factor favored Reuters. So 2 factors for Ross, 2 factors for Reuters. Balancing them all, though, the court gave the least weight to factor 2 and the greatest weight to factor 4, ultimately arriving at its determination of no fair use.
Thank you very much for this interesting overview, Lauren. It was great to have you with us today. So, in summary, the court rejected the fair use exception and decided that the AI training infringed Thomson Reuters copyright. The fact that Ross AI was intended to compete with Thomson Reuters in the same market was a major factor for the court's decision. It's also interesting to note that the court only ruled on non-generative AI. However, many of the AI models currently being developed are generative, on which the court has not taken a position. There are currently a lot of cases pending before the courts involving similar issues in AI training, not only in the US, but also in Europe and particularly in Germany. It will be interesting to see how other courts decide on these points. Now, if you're interested in learning more about the legal implications of AI, please feel free to get in touch with us. And also be sure to follow us so you don't miss out on the latest digital transformation news. Thank you for watching.